In this video, I'm going to discuss the updated Louisiana laws regarding illegal possession of marijuana. Specifically, I'll discuss the schedule of the drug and the penalties for illegal possession and distribution. These laws change every now and then. However, I'll be discussing the most recent laws. Just keep in mind that every drug possession case is different. The penalties you'll see do not consider the criminal record of the defendant or other aggravating and/or mitigating factors of the case. Marijuana in Louisiana is a Schedule I drug. Marijuana refers only to the organic plant material, whereas THC and CBD are extracts or compounds processed from the raw plant. Marijuana has both recreational and medical uses. While it is habit-forming, it is not technically addictive in the clinical sense. Marijuana has undergone lots of recent legislation here in Louisiana. Specifically, doctors can now prescribe or recommend marijuana to treat certain diseases and disorders. And the most recent legislation now allows the raw smokable form to be prescribed, which is going to lead to a big change in the way police officers do stops and searches, basically making Louisiana a throughway for drug trafficking. So let's look at the penalties here for illegal possession of marijuana. When I discuss the penalties, I'm discussing illegal possession rather than legal possession, which legal possession would be possession of marijuana with a prescription. So possession of marijuana, first offense of 14 grams or less, is now punishable by a $100 fine. So it can't get jail time on this charge. In fact, if a defendant is getting a charge for by a police officer, the police officer must give him a summons or a ticket. He cannot book the defendant. Now, if the defendant has in his possession more than 14 grams of marijuana, then he's looking at 0 to 6 months in parish jail and a fine of up to $500. So 14 grams is the threshold. And possession of marijuana, second offense, when it's more than 14 grams, 0 to 6 months. 14 grams or less, it's still going to be a first offense. Possession of marijuana, third offense, is if there's more than 14 grams, 0 to 2 years with or without hard labor, and a fine of up to $2,500. Fourth offense, more than 14 grams, 0 to 8 years. And these are felony charges. Third offense and fourth offense are felonies. Prior convictions of possession of marijuana can only be used to enhance the new charge to make it either a second, third, or fourth offense if the date of offense for the new charge is within 2 years from the completion date of probation or the sentence from the prior. So if there is more than 2 years between completion of the previous sentence and the date of offense of the new case, then that previous conviction cannot be used to enhance the new charge. 2.5 pounds or more, then it becomes possession with intent to distribute marijuana. These are much more serious charges. With possession with intent to distribute marijuana and distribution of marijuana, then the defendant's looking at 1 to 10 years with or without hard labor and a fine of up to $50,000. If the defendant is accused of having 2.5 pounds or more and it's possession with intent to distribute or distribution, then it's 1 to 20. The smell of weed is probable cause to search a vehicle in Louisiana. However, the smell of weed is no longer probable cause to search a residence in Louisiana. Beginning August 1st, 2022, new laws went into effect that now more clearly control probable cause searches in Louisiana. We've been getting a lot of calls and a lot of questions about this issue. People are catching weed possession charges and calling us saying that they should be able to get the charge thrown out because the police officer searched their car saying he smelled weed. The question is always, isn't it true that cops can no longer search my car after smelling weed? Look, they can still search your vehicle. In fact, the legislature created a new law as well that makes it illegal to smoke marijuana in a vehicle while it is being operated on a public road, regardless of whether or not you have a prescription. This new law basically protects the police officer's ability to use the smell of marijuana to search a vehicle. If the cop says he can smell marijuana, that gives him probable cause to believe you were smoking marijuana in the vehicle. Therefore, he can search the vehicle for evidence to support the probable cause. The legislature probably created this new law to counteract any possibility of a defense that the defendant had a prescription. Now that the smokable form of marijuana is legal in Louisiana with a valid prescription, there would be issues with this type of search. There would have been the possibility that the defendant wasn't doing anything illegal because he had a prescription. Therefore, there would be no probable cause to search because there is no crime to investigate. But since the legislature passed this new law making it illegal to smoke in a vehicle on the road, the police still had the smell of marijuana as probable cause to search in their arsenal. This was actually very clever by the legislature. As of August 1st, 2022, it is more illegal than ever to smoke marijuana in your car, and police now have more power than ever to search your vehicle based on the smell of marijuana. Louisiana law is not the same as the law in Maryland or New York. Every state has different marijuana laws and treats this issue of the smell of marijuana as probable cause to search your vehicle differently. So be careful what you read online. Much of the confusion about this issue is that the Louisiana legislature did pass a law that limits the ability of police officers to search a residence based on the smell of marijuana. However, this does not apply to vehicles. The Louisiana legislature recently created Article 162.4 of the Code of Criminal Procedure, which states that the odor of marijuana alone shall not provide a police officer with probable cause to conduct a search warrant without a warrant of a residence. This law went into effect August 1st, 2022. The general rule about privacy in the home is that the police must have a search warrant signed by a judge to search a residence because of our constitutional right to privacy. There are exceptions to the warrant requirement. If the officer smelled marijuana emitting from the residence, he would have had probable cause to believe a crime is occurring. He could then enter the residence without a warrant. The exception officers would use is that exigent circumstances existed, so the officers needed to enter the home immediately to protect the evidence. The concern is that if the officer had to go find a judge to sign a warrant, the weed could be hidden or destroyed or smoked by the time he comes back with the warrant. Now he has to go get that warrant. The smell of marijuana alone does not support probable cause to search a residence without a warrant. The reason is that it is now legal to smoke marijuana with a valid prescription in Louisiana. There could be someone in the house with a valid prescription smoking weed. That's legal. Therefore, there is no probable cause to believe a crime is being committed. True, they may not have a valid prescription and therefore are possessing marijuana illegally, and so there's a crime being committed. But the right to privacy in a home has been weighed and is determined to be more important than the officer investigating a potential marijuana possession case. The right to privacy in a home is much greater than a vehicle on a public roadway. That is why the legislature has made it so the police can still search a vehicle based on probable cause supported by the smell of weed. That is also why they created 32-300.4.1. That new law eliminates the possibility that no crime is occurring because even if they have a valid prescription for marijuana, they cannot smoke in a vehicle on a public highway. Keep in mind what this law is really saying. It says that the odor alone is insufficient to support probable cause. Therefore, if the police officer can articulate other facts in addition to the odor that justify reasonable probable cause that a crime is occurring, he may be able to enter the residence without a warrant. For example, the police officer may look inside and see marijuana in plain view on the coffee table, or see marijuana plants growing, or gets verified information regarding the cultivation of marijuana from an informant. These facts may be combined with the odor of weed to support probable cause and allow him to enter the residence without a warrant. There will be cases like this in the near future, and it'll be the judge that'll end up making the call regarding the validity of these searches. Also, this new law just says that the odor of marijuana doesn't support probable cause to conduct a search without a warrant. It doesn't say that the odor alone is not probable cause. It just says that the police can't enter without a warrant. Therefore, the police officer could go to a judge and get a warrant based on the odor of marijuana alone, then execute the search warrant. These days, police officers can get warrants very quickly since it's all digital. The police no longer have to physically go to the courthouse and find a judge to sign it. It can all be done in minutes electronically. The judge could sign the search warrant, then the officer can go into the home with the search warrant based on probable cause supported by the smell of marijuana. So if you picked up a weed charge, whether you think you have a good case or not, give us a call. We'd be happy to help.